Hi everyone, very good evening and welcome back to Crack Grade B. So in today's class, we are going to talk about prohibition of insider trading, right? So SEBI has made regulations regarding that. So first we are going to understand that only. Now first let's talk about what do we mean by an insider trading, right? Insider trading means that you are in a management, you are having a managerial profession, right? By virtue of that particular control in an enterprise, you are having a certain information, right? That particular information, it is having two characteristics. First of all, this is price sensitive. Price sensitive ka matlab, if this information will go out, then it will impact the pricing of the securities, number one. And number two, this information is not yet public. That means general public does not have information of this particular whatever data piece, right? So we have understood that there are two things. Number one, you are in the possession of certain non-public price sensitive information, right? Non-public price sensitive information. So you are having this particular kind of information, and if you have this information and now if you will indulge in trading, you will make profit at the cost of general public, right? So you will make profit at the cost of general public. So this is not allowed. SEBI will never allow that loss be incurring for the general public, right? SEBI will never allow this. So this is why this prohibition of insider trading regulation has been made. Now you have got the crux, because if you are studying for SEBI Legal, I guess this is the basic level of information which everyone has, right? So we will be studying about its detailed manner कि कौन होते हैं connected person, right? What are the steps you should be taking if you are having certain sort of insider information? What should be the what you can say precautions should be taken? So let us see this. Number one, let us know who the connected person is. So any person who has during the 6 months prior to the concerned act has been associated with the company directly, indirectly, in any capacity which allows such person access to unpublished price sensitive information. So whenever the SEBI will try to determine that whether a particular person has done insider trading or not, so the SEBI will see that whether such person is connected person or not. That means whenever such act has happened, if that act and 6 months before that, if between this particular period the person was connected with the company, then that person will be called as a connected person, right? Person falling within such categories, they also shall be deemed to be a connected person. The immediate relatives of connected person, they will be also be treated as a connected person. Holding company, associate company or subsidiary company, intermediary or an employee director thereof, investment company, trustee company, asset management company, an employee or director thereof, official of stock exchange, they are also treated as connected persons to the company. Members of board or trustee of mutual funds, directors of asset management company of a mutual fund, official or employee of a self-regulatory organization, banker of the company, concern, firm, trust, HUF, association of persons, wherein a director of a company or his immediate relative has more than 10% holding. So we are talking about all of these are treated as a connected person in terms of company, right? So if I am talking about company A, they all will be treated as connected to the company. Why? Because either you are a banker of the company, either you are managing the assets of the company, or you are managing the funds of the company in terms of mutual funds, right? You are trustee of the company, or you are employee or director of the company, or you are holding associate or subsidiary company of this particular company. So any such relation with this company will be treated as a connected person. Okay, because see, by virtue of this status they all have certain price sensitive information about that particular company. ठीक है, इन सब के पास ऐसी कोई information है that might not be available with the general public. ठीक है, general public के पास में वो information नहीं है. So this is why we are calling them as a connected company. Generally available information means that is accessible to the public on a non-discriminatory basis. Public information means which anyone can access. There is no prohibition onto that. So जो information सबको available हो, that is called as generally available information. Insider means what? Insider means a connected person. We have seen what is the definition of connected person, right? Who is in possession of or in excess of unpublished price sensitive information. Unpublished, which is not there with the public. Price sensitive means if this information leaks out in the public domain, then it is going to have an impact on the pricing of securities for the company, right? Now, unpublished price sensitive information, what does it mean? Let us see that as well. So it means any information related to company securities directly or indirectly that is not generally available, upon becoming generally available is likely to materially affect the prices of security. So normally what is considered as a price sensitive information is this: financial results, dividends, capital structure changes, that means the proportion of debt or equity, right? This is called as the capital structure. If a company thinks that now we are going to buy back the shares, so this particular information will be having an impact on the pricing of security, right? So this is capital structure means debt equity ratio, merger, demerger, acquisition, delisting, disposal, expansion, changes in key managerial personnel. All of this is considered as a price sensitive information. Like when Elon Musk came into Twitter, that did have an impact onto the pricing of shares for the Twitter. Okay, so that's what changes in key managerial personnel, ownership, etc. anything, this is considered, generally they are considered as the price sensitive information. This is not the exclusive list, there can be other things as well, but generally this is considered as a price sensitive information. Next is communication or procurement of unpublished price sensitive information. Now let us see what is prohibited is that you will not trade at the cost of general public, right? But sometimes you need to disclose the information because of the virtue of the contract, or because of in order to fulfill any kind of statutory or legal information, legal requirement, right? So for certain cases you need to provide certain data, and we are not prohibiting you from that, but we are prohibiting you for trading on the basis of certain information which is not available with the general public. Okay, so let us see this. So no insider shall communicate, provide, allow access to any unpublished price sensitive information to person except legitimate purposes. That means exception is there. There can be legitimate purposes that can exist for which the information can be provided, right? Now unpublished price sensitive information, it may be communicated in a transaction which includes obligation to make an open offer under the takeover regulations, where directors of listed company is of informed that sharing such information is in the best interest of the company, right? So you are going to do some takeover, etc., and because of those regulations you have to disclose your price sensitive information, right? So जब आप इसी किसी तरीके के फाइनेंशियल कॉन्ट्रैक्ट में एंटर करते हैं, व्हेन यू आर एंटरिंग एनी सॉर्ट ऑफ फाइनेंशियल कॉन्ट्रैक्ट, you need to disclose price sensitive information because that shows your financial depth. ठीक है, तो वहां पे you please disclose. We are not going to implement prohibition of insider trading. Structural digital, this is also along with that only. Structured digital database should be maintained containing the nature of information and the names of persons who have shared to whom. So now this is a accountability mechanism. So there are informations which is not yet published in general domain, and who who are the people who have shared it and to whom, for what purpose. So that includes accountability, that you have the track where this information has gone. Database is preserved for a minimum period of 8 years. Now see, they are prohibiting you from trading when you are having in the possession of price sensitive information. But suppose I am a director in a company. Obviously, being a director, I have access to certain information which is not yet in public domain, right? But I would like to sell my shares because of any matter whatsoever. I might be in the need of money or anything, right? I might want to manage my portfolio. So is it the case that I cannot even sell my shares? So answer is no, there is no such prohibition. You have been told that yes, you cannot trade when you are having certain price sensitive information, but there is an exception which has been made, that if you want to trade normal course, right, you do not have any intention to defraud the public, then in such a situation we have provided you a procedure. And now what is the procedure? Let us see that. So transaction should be, now this is exception for the insider trading. Transaction is an off market transfer between insiders. Off market means market में आप किसी को भी नहीं दे रहे हो. Inside, between insiders, this is a transaction. So suppose one director is selling to another director. It was carried out through block deal, or it was pursuant to a trading plan. Trading plan needs to be submitted by you within for a year, right? We are going to see this. Pursuant to a statutory or regulatory obligation, pursuant to exercise of stock options. Companies give stock options to their employees, etc., right? So that is what they are talking over here, that can be done. In the case of non-individual insiders, individuals who were in possession of such information were different from the individuals who were taking trading decision, and appropriate and adequate arrangements were in place. Now what are the trading plans? Let us see this. So trading plan, you have insider, if you want to do the trading, you have to submit your trading plan in advance to the compliance officer for approval, right? So you have to tell that yes, this is what I want to trade and this will be my mechanism, etc., etc. So through this, if you have taken an approval, then your case will not be considered as a case of insider trading. So trading can only begin after 6 months from public disclosure of plan. So whatever plan you have given, they will make a public disclosure of it. Trading as per trading plan cannot be executed 20th trading day prior to last day of any financial period, and second trading day after the disclosure of financial results. So it has been said that whenever you are disclosing your financial results, so once financial period ends 31st March, after that you disclose your financial results, right? So the period between that, 20 days between that, that is a crucial period, because the financial results have been made, lekin they have not been disclosed, right? So there is a gap. So that particular 20 days gap, you cannot involve yourself into trading, right? So trading as per the trading plan, it cannot be executed between that particular period. It should not be less than 12 months. So your plan should be for 12 months. Two trading plans should not overlap. That means at a time you can execute just one trading plan only, right? Trading plan means your planned way of purchasing, selling securities, right? And this plan has been made by whom? Who is an insider to the company. So you could be a key managerial personnel, you could be employee, you could be director, right? And you want to involve into the trading of the company's securities that you are having. So you just have to intimate beforehand. That is what they are requiring, right? Trading plan that entails trading in securities for market abuse is prohibited. That means in any way we would not allow you to make profits on the cost of general public, right? That we are not going to allow you. Trading plan that is once approved is irrevocable, and you have to implement that particular trading plan. Why? Because public disclosure has been made already. Now let us see, the disclosure shall be maintained by the company for a period of 5 years. What are the disclosures? Let us see this. So initial disclosures to the company, categories who are required to make disclosure, particulars, time period. So upon appointment, promoter, key managerial personnel and creditors, they have to, the directors, they have to tell holding of securities of the company. On the day of appointment, how many securities you are holding. Remember, minimum 5 years you have to disclose this information. So promoter, KMP and director, whatever security they are holding, they have to tell within 7 days of appointment, right? Very important. After that, promoter, employee and director, whatever number of securities they have acquired or disposed, right, whether in one day or series of transaction over a quarter, aggregates to a traded value in excess of 10 lakh rupees. So in a quarter or just in one day, whatever might be the case, in a quarter if you have traded in excess of 10 lakh rupees, then within 2 trading days of the transaction you have to make a disclosure. That means who is going to make the disclosure? Company, right? This disclosure is internal disclosure. Next is disclosure to be made by the company public. So company required to notify stock exchange. Okay, so company has to require, just wait for a second. Stock exchange should be notified for what? In case value of securities which are traded by a promoter, employee, director, whether in one day or over a quarter, they have traded in excess of 1 million rupees. 1 million rupees, that is 10 lakh rupees. Incremental transaction after the above to be made when transaction effected after the prior disclosure crosses the monetary threshold of 1 million or such other rupees as may be specified. That means first you have done a transaction of 1 million and after that you are doing successive transactions over 1 million. So once it reaches 1 million value, that is 10 lakh rupees, you have to notify stock exchange. If it goes beyond 1 million, then every time you have to notify to the stock exchange. So please remember the 1 million, that is 10 lakh rupees criteria, and you have to notify to the stock exchange. Notification has to be made within 2 trading days, right? Now there are few definitions. Let us see these definitions quickly. Informant means an individual who voluntarily submits to the board voluntary disclosure form related to alleged violation. Now this is also called as whistleblower. Whistleblower means a person who tells about the some irregularities that has been carried out. So a person who tells to the board, that means SEBI, that insider trading laws are violated in a company, regardless of whether such individual satisfies the requirement etc. for a reward or not, we'll call him as an informant. Informant incentive committee, high powered advisory committee will be constituted by the board. Now, what is irrelevant, frivolous information not to be read, because we understand that what is irrelevant information which does not constitute the violation of insider trading. Monetary sanction means any non-monetary settlement terms in the nature of disgorgement aggregating to at least rupee 1 crore arising from the same operative facts contained in the original information. So over here we are talking about that if there is a disgorgement of at least rupee 1 crore, then it will what you can say attract the monetary sanctions, right? Next is original information. Original information means any relevant information derived from knowledge not known to the board etc. It's sufficiently specific. Own analysis Easily understandable. Now over here what is important is informant has to submit the original information to the board. Legal representative will verify and contact details of informant and will maintain confidentiality because he has disclosed, so his information must be kept confidential. Over here not really very important. This is the something which is important. Informant award. So SEBI has announced these particular awards so that more and more people will complain about the insider trading, right? So until and unless there is no incentive, why would anyone would like to take such an amount of risk? So board may at its sole discretion will can award an informant. Amount of reward shall be 10% of monetary sanctions and shall not exceed 10 crores, right? Next is, if total reward payable is less than or equal to 1 crore, then the board may grant reward upon issuance of final order. जब तक final order नहीं आएगा तब तक they will not give. Where total reward payable is more than 1 crore, the board may grant an interim reward of not exceeding rupee 1 crore. If there is such a huge what you can say insider trading scam has been released by informant, so if reward is not up to 1 crore, then you can wait till final order. But if reward is more than 1 crore, then at that time board can think that let us give us some interim reward meanwhile the final order comes, right? It can be given up not exceeding 1 crore and remaining amount will be paid only of the collection or recovery of monetary sanctions amounting to at least twice the balance reward amount payable. In case of more than one informant jointly providing the original information, the reward shall be divided equally. Award shall be determined by whom? Award shall be determined by the board. Rejection or claim for the reward. Wait for a second. Rejection or claim for the reward. No reward will be made to the informant who does not submit the original information, who willfully refused to cooperate, right? Against whom board may initiated criminal proceedings because he might have filed a frivolous complaint, right? Or motivated complaint which does not have any truth behind it. Informant confidentiality means, see, if a particular person has been providing an information, then you have to ensure his safety and security. So no person shall have the right to compel disclosure of identity of the informant. Original information and identity of informant shall be held in the confidence, and it is exempted from RTI as well. Nobody can ask this particular information through RTI as well. So this is under exemption. Protection against retaliation and victimization. So informant who believes that he shall be subject to retaliation may approach the competent court and tribunal for the appropriate relief. So this provision is also there. If you feel like that your employer about whom you have disclosed a certain information, they might harass you, so in that case you can approach to tribunal. No amnesty will be given for violation of the security laws. What are the functions of informant incentive committee? So this particular committee shall be assisted by the Office of Informant Protection, and they shall give the recommendation of eligibility for reward and determination of 7E and 7G. Public dissemination and incentivization of informant. So board shall upload the website annual report, press release informing the public, and press release that reward has been paid. Now this ensures accountability of board as well, right? So you have to tell that yes, we have received certain information from an informant and this is how we have given incentives to him. So this is going to, what you can say, have a spillover effect over others as well. ठीक है, दूसरों के ऊपर भी एक spillover impact होगा. Wait. So code of fair disclosure formulated by board of directors of every listed company and policy shall be framed in accordance with schedule A. Code of conduct formulated by the directors, policy shall be framed in accordance with schedule B. So over here what is happening is that you have, as a board of a company, you have to make the policies for fair disclosure. Fair disclosure means informations which you want to disclose to the public. So you should be having a code for it. Apart from that, code of conduct means while dealing with the non-public price sensitive information, how you should have behaved, right? So this particular schedule has been given at the back of the document. If you want, you can have a one-time read over it. Institutional mechanism for it. So CEO, MD, intermediary shall put in place adequate systems of internal control. This we are talking about a company, right? So being the owner of the company, being the director of the company, this is your responsibility that you have to ensure any kind of information should not go beyond your company. After that, internal controls will include what? So this is how you will ensure all employees who are having the price sensitive information, they will be identified. Why identified? Because this is how you will ensure their what you can say, accountability. All non-published information shall be identified, confidentiality shall be maintained, there will be adequate restrictions on communication, and the list of all employees to whom information has been shared shall be served to all the employees, right? So there are confidentiality agreements which will be made signed by the employees. You cannot breach that particular agreement. Audit committee shall review the compliance of at least once in financial year. Audit committee क्या होती है? This is a committee which is made of board of directors, right? Board of directors, at least 3 board of directors are there in the audit committee. Their function is that they review financial statements, they give the recommendations about auditors appointment, they see auditor reports as well, right? They see internal controls as well related to different sorts of things. Internal control का मतलब होता है how strong your internal mechanisms are to prevent any sort of fraud, any sort of leakages, like that. Now the listed company, they shall have a whistleblower policy. Very important. Whistleblower policy means if any particular person wants to reveal any kind of fraudulent thing which is happening in a company, he can reveal it without facing any particular consequences. Okay. Now schedule B, this is minimum standards of code of conduct. So the compliance officer shall report to directors and chairmen of audit committee at such frequency not less than once in a year. All information shall be handled within the organization. Trading restrictions period shall be made applicable from the end of every quarter till 48 hours after the declaration of the financial results. That means till the day you have disclosed the financial results, end of the quarter, till the day you have disclosed your financial results, यहाँ पे भी restricted रहेगा. And once the results have been disclosed, मतलब what have been the results of this quarter, after that 2 days time period, you cannot trade in anything in related to securities. So this is how it goes. End of the quarter, disclosing financial results, 2 days after it, no trading, no trading. Okay. The timing for reopening of the trading window shall be determined by the compliance officer, which in any event shall not be earlier than the 48 hours after the information becomes generally available. So compliance officer will determine that after what time period we shall allow you trading, and in that particular case it cannot be, at least 48 hours needs to be maintained. So now we have done this particular thing, you have to see what are the important provisions. So few things are important, like reward mechanism is important, right? So please remember that reward mechanism. What else is important over here? Most of the things are general in nature, right? So that can be done by you easily. So monetary sanctions, These are awarded by the board. Please remember this as well. So, monetary sanctions shall mean any non-monetary settlement terms in the nature of disgorgement aggregating to at least rupee 1 crore arising from the same operative facts, right? So, the information that has been disclosed, it involves the disgorgement of at least rupee 1 crore. Please remember this, and these are the yes, and this particular chart as well. So the disclosures which need to be made, especially this, company is required to notify the stock exchange. This is it for this particular class. Thank you so much for joining in. We have completed Prohibition of Insider Trading.